All right. In the meantime, let's shift focus to other stories this afternoon, where a pivotal legal flashpoint has now reignited with the debate over the delicate balance between judicial independence and executive powers. Now, the Supreme Court of India has stayed a Lokpal order, which said that the Lokpal and the Lokayuktas Act of 2013 also allows for investigation against High Court judges. This development and the Supreme Court's observation on the matter has raised profound questions about the jurisdiction of anti-corruption bodies and the sanctity of judicial autonomy. Before we get to hear of the matter, let's clarify the scope of Lokpal's autonomy. Now, when it comes to establish under the Lokpal and the Lokayukta Act of 2013, the Lokpal is empowered to investigate allegations of corruption against, as far as when it comes to the Prime Minister, with specific safeguard, union ministers, members of parliament, of Group A, B and C and D officers and officials of the central government, chairpersons, members, officers and directors of any board or autonomous body, either established by an act of parliament or wholly or partly funded by the union or the state government. There are certain entities receiving foreign donations above rupees 10 lakh per year under the FCRA or Foreign Regulation Act. Notably, this act does not explicitly include sitting judges of the highest judiciary within its purview. So why is the focus back on Lokpal's jurisdiction, as the controversy that began on the 27th of January this year, when the Lokpal, led by its chairman and former Supreme Court Justice A.M. Khanvilkar, ruled that it possessed the jurisdiction to entertain complaints against a sitting High Court judge. Now, this interpretation was based on Section 14(1)(f) of the Lokpal Act, which covers persons in body established by an Act of Parliament. The Lokpal contended that since High Courts are established by the Constitution, a document adopted by the Constituent Assembly, their judges also fall within the definition to be investigated. However, on the 20th of February, that is yesterday, a special three-judge bench of the Supreme Court of India, comprising of Justice Gavai, Justice Suryakant and Justice Abhay, has stayed this order. Now, the Supreme Court bench described the Lokpal's decision as very disturbing and as a matter of great importance concerning the independence of judiciary. Notices that have now been issued to the union government and the registrar of Lokpal seeking their response on the matter, where the Supreme Court bench also issued an injunction to prevent the complainant from disclosing the name of the judge and directed him to keep the complaint as confidential. Let's get in a word from our guests who are joining us here on the broadcast. Kapil Sankhla is connected with us right now. Kapil Sankhla, what is your point of view here as far as the Supreme Court staying the Lokpal's order, which entertained complaints against a High Court judge, terming it as very disturbing?
Well, on the face of it, what was done by the Lokpal completely looks erroneous, for the reason that there are checks and balances when you question the conduct of a High Court judge. Or a Supreme Court judge, of course. And those checks and balances are necessary to protect the independence of the judiciary and the independence of an order or a judgment that is passed. Otherwise, it's a slippery slope. Now, why I think the decision was erroneous as far as the Lokpal is concerned is this, that every judge is independently a High Court judge and High Court unto itself. And therefore, it is a post that is not a statutory post, but a constitutional post. So now, under those circumstances, you cannot bring them under the ambit of Lokpal. This is what my understanding is, of course, subject to correction. And secondly, once there are checks and balances, and which are there to question a conduct of a High Court judge, you cannot bypass it and bring in a shortcut. So what cannot be done directly cannot be done indirectly. That's settled proposition of law. And thirdly, independently, let us forget law for a second. Every stakeholder of the judicial system, that includes a High Court judge or a judge, and the lawyers and advocates, are to be protected as far as their independence is concerned. The moment you make them second guess what they're going to say or going to do, or the cases they're going to take up, you're bringing in a very dangerous precedent where justice will suffer, where common man will suffer, where every person who is relying on justice, law, and order is going to suffer. So I think what has been said by the Honorable Supreme Court is absolutely correct. It is, of course, subject to interpretation. Having said that, there are previous judgments and precedents that also clearly, categorically stated that the names of the judges have not been given in the Act, and the position of a High Court judge or judiciary or justice is through the Constitution, and they cannot be a part of the Lokpal or the Lokayukta Act. So this is what my understanding is.
All right. Abha Singh is also connected with us. Abha Singh, what is your understanding with the Supreme Court staying Lokpal order, giving itself jurisdiction over High Court judges? What does it mean?
See, as per the current position and also by Supreme Court's various orders, it's very clear that in case you want to put any judge under the Prevention of Corruption Act, if you as in this case today, then the prior permission of the Chief Justice is required. That was primarily the reason, because they felt that the judiciary's independence should be maintained. These are constitutional positions. So Supreme Court has this has been the prevalent practice. But I would like to say that fine, if the Lokayukt had taken permission from Chief Justice and then done this, there would have been no problem. But nonetheless, if we are protecting the judges, we need a more credible mechanism whereby this increasing corruption can be looked into, because even the judges are coming from the same society from where other department people are coming, and we are seeing increasing corruption in police, income tax, customs, ED. So how can we think that judges are not going to be corrupt or not take money? And I'm sure some of them can happen. So I personally feel, as of now, Supreme Court is right as per the prevailing practice, the prevalent law, that Lokayukt has gone beyond his brief, and that is why Supreme Court has stepped in. But yes, in future, Supreme Court does need to bring out a mechanism to control this increasing corruption in the judiciary.
Well, notices that have been issued for a response on the same matter. Thank you very much, Kapil Sankhla and Abha Singh, for joining us here on the broadcast with your point of view. Let's get in a word from our legal editor as well. Harish is with us right now, because Harish, the Supreme Court, they're invoking judicial independence. Does this standoff trigger a larger debate? Is the judiciary beyond legal scrutiny?
Yes, that's, Amita, very, very significant observations made by Justice B.R. Gawai, who happens to be the senior-most judge of the Supreme Court. He was heading the bench. He said that this is a matter of great importance pertaining to the independence of the judiciary, and the ruling by the Lokpal is prima facie very disturbing. This is what the words used by the Justice B.R. Gawai while staying the Lokpal order, which had holding that he had power to hearing regarding complaints against High Court judges, had proceeded against High Court judges, and had even begun hearing. What is important, Amita, is that two very significant people, that is Solicitor General of India Tushar Mehta and also Senior Advocate Kapil Sibal, who was assisting the bench. Remember, he is also the President of the Supreme Court Bar Association. He said that such a ruling is fraught with danger, and therefore Supreme Court should stay it and also laid on guidelines in this regard. So after hearing these arguments, the bench, special bench, we comprised of number 2, 3 and 4 judges of the Supreme Court, Justice B.R. Gawai, Justice Suryakant, Justice Abhay S. Oak, stayed the Lokpal ruling and has issued notice, as you rightly said, Amita, to the centre to file a detailed affidavit, and also the registrar of Lokpal.
So look at the powers there is the Supreme Court. They're staying the Lokpal's order, which entertained complaints against a High Court judge, terming it as very disturbing. Harish, thank you very much for joining in. Heading into a short break.